Hello everyone, welcome to Universal Group of Institutions. Welcome to the series where we are discussing articles of Indian Constitution. Till now we have discussed Article 1 to Article 12. In the previous video we had discussed about Article 12. If you remember from our earlier discussion, Part 3 of Indian Constitution starts from Article 12 and ends at Article number 35. Part 3, it deals with the chapter of fundamental rights. In Article 12, we have discussed that they have defined what is state under Article 12. Right? So, state shall not violate the rights of the citizens given under Part 3. But what is state? That definition has been given under Article 12. In today's video, we will be discussing about Article 13. Article 13 is about a very special power of judiciary, that is power of judicial review. Judicial review, it is a power given to higher judiciary in India, which means that any law passed by any legislature or any directive, any rule made by any government, if it is violative of any of the fundamental right as given in Part 3, then such a law has to be declared by the judiciary as void. This is what broadly judicial review is. Now let us discuss in detail the provisions of Article 13. Article 13, it has 4 subparts. Let us first understand Article 13 subclause 1. Article 13 subclause 1 says, all laws in force in the territory of India immediately before the commencement of this constitution, in so far as they are inconsistent with the provisions of this part, shall to the extent of such inconsistency be void. Meaning they are talking about laws which were in force before the commencement of Constitution of India, meaning the laws which were passed by British when they were ruling over India. Even such laws which were passed by British, if they are violative of any of the fundamental right given by the Constitution on 26 January 1950, to the extent of violation, such laws will become void. That is what Article 13 subclause 1 says, that pre-constitutional laws, if they are violating any of the fundamental right, they will become void to the extent of inconsistency. Let us, in this regard only, let us try to understand one very important concept, that is doctrine of eclipse. Doctrine of eclipse, let me read it for you first. It says that pre-constitutional laws inconsistent with fundamental rights are not dead but rather dormant or eclipsed. What does it mean? Let's say there is a law which was passed by British in 1940. Right? In 1950, later on, the Constitution has given us certain fundamental rights. Now, let's say the Act of 1940, it is violating Article 19 of Indian Constitution. Because it is violating one of the fundamental rights, this Act which was passed in 1940 will become dormant. It will be void, but it will be void of what type? It will become dormant. Meaning, if later on Parliament amends this Act of 1940 and they amend in such a manner that this amended Act is not violating Article 19, then this Act will again become alive. Or if, let's say, Parliament amends Article 19 itself so that the earlier Act of 1940 is not violating Article 19, then also this earlier Act of 1940, it will become alive. Because the Act of 1940, it was not dead, it was only dormant. So that is what doctrine of eclipse means, that the earlier laws, the laws prior to Constitution coming into force, if that law is, it is violating any of the fundamental right, then to the extent of that violation, firstly, it will become void. Secondly, the law will be only dormant, not dead. Moving forward, let us discuss Article 13 subclause 2. Article 13 subclause 2 says, the state shall not make any law which takes away or abridges the rights conferred by this part, and any law made in contravention to this clause shall to the extent of contravention be void. So Article 13 subclause 1, we have seen it was about pre-constitutional laws, but Article 13 subclause 2 is about the laws which will be made by legislature after Constitution coming into force, right? So it says, after Constitution coming into force, no such law shall be made by any legislature which is which abridges the fundamental rights given to citizens in this part, that is in part 3. If it violates, to the extent of violation, such a law shall be declared as void. It is very simple that no law passed by any legislature, no rule made by any government shall be violating citizens' fundamental rights. Right? That is what is given under Article 13, subclause 2. And hence, with this discussion, we have also understood another very important doctrine, which is called as doctrine of severability or severability. It is a legal principle that allows a court to uphold a law or contract even if part of it is found to be invalid or unconstitutional. What does it mean? As we have seen in 13 subclause 1 and 13 subclause 2, that let's say there is a law which has 5 subsections. Let's say out of these 5 subsections, only one subsection is violative of any of the fundamental right. Let's say subsection 2 is violative of Article 20. In such a case, what will be happening is judiciary will not be declaring the whole law as void, but only the subsection 2 of this particular law will be declared as void. So that is what doctrine of severability means, that only to the extent of violation of fundamental right, this law shall not be enforced. Remaining aspect of the law will be applicable. So I hope this doctrine is clear. It is applicable to both pre-constitutional laws as well as post-constitutional laws. On the other hand, doctrine of eclipse, it is applicable only on pre-constitutional laws. Now moving forward, let us discuss Article 13 subclause 3. Article 13 subclause 3 basically defines what a law is. They have given a very wide definition of law under Article 13. Let me read it out for you people first. It says, in this article, unless the context otherwise requires, a law includes any ordinance, order, bylaw, rule, regulation, notification, custom or usage having in the territory of India the force of law. So not just the laws passed by legislature, but any rule, regulation, notification made by the government, and in fact customs which are there in practice, which has nothing to do with the government, even if these things are violating any of the provision of the fundamental right, any of the part of fundamental right, then that will be coming in the definition of law and has to be declared as void by judiciary. That is what Article 13 subclause 3 part A says. Part B says laws in force. So we have seen in the definition or in the Article 13 subclause 4 the use of word law in force. They have defined what is law in force. Law in force includes laws passed or made by a legislature or other competent authority in the territory of India before the commencement of this constitution. Right? So such laws which were formed or passed before the commencement of this constitution and not previously repealed. They were not repealed as well. Notwithstanding that any such law or any part thereof may not be in operation either at all or in particular areas. It does not matter whether any of this law which was not repealed is not in force or it is not applicable in some part of the country. It does not matter, right? They will also be included into the definition of law in force, right? So Article 13 subclause 3 basically defines law. They have given a very wide definition of law, not just the power of legislature. In fact, executive and society also cannot come up with such customs, such morals, which is violative of fundamental rights of citizens. Now the last part, Article 13 subclause 4 of this article. Article 13 subclause 4, please remember, it was not there in the original constitution. It was added to the constitution by 24th Constitutional Amendment Act in the year 1971. Right? There is a big debate, there is a history about why this article was added to the Constitution of India. We'll be discussing that part as well. Firstly, let me read what does Article 13 subclause 4 says. It says, nothing in this article shall apply to any amendment to this constitution made under Article 368. Meaning, if under Article 368, which gives Parliament the amending power to the Constitution of India, if under that article Parliament passes a law which is violative of fundamental right as well, then that law cannot be reviewed by judiciary. Right? Now let us try to understand under what circumstances Article 13 subclause 4 was added. So this debate was very old, right? Whether under the definition of law in Article 13 subclause 3 Constitutional Amendment Act also comes or not, right? This issue was first dealt by Supreme Court in the year 1951 in a very famous case named as Shankari Prasad versus Union of India case. Right? In this case, Supreme Court has said that under the definition of law in Article 13 subclause 3, Constitutional Amendment Act, they do not come, and hence through constitutional amendment the Parliament has the power even to take away fundamental rights of citizens. That is what the stand of Supreme Court was in 1951. But Supreme Court reversed its position in 1967 in another very famous case named as Golaknath versus State of Punjab. Golaknath versus State of Punjab case of 1967. Here Supreme Court has completely reversed its position of Shankari Prasad case, saying fundamental rights are sacrosanct. Even under Article 368, the mechanism which is given to amend the constitution, even following this mechanism also, Parliament cannot abridge fundamental rights given to citizens under Part 3. So that was the Golaknath case. In order to nullify this ruling of Supreme Court, Parliament by 24th Constitutional Amendment Act in 1971 added Article 13 subclause 4 to the Constitution of India. So that was the history behind addition of Article 13 subclause 4. Again, it was challenged in Supreme Court and the debate was finally settled through a very important case again named as Keshwanand Bharti case of 1973. In Keshwanand Bharti case, what Supreme Court has said is, Supreme Court first upheld Article 13 subclause 4, but Supreme Court has further said that there are certain aspects of the Constitution which are very basic, which are very core to which form the core of Constitution of India, and such aspect of the Constitution of India shall not be changed, shall not be altered. If those aspects of the Constitution are altered or changed, the Constitution will lose its true value, its true sense, right? And hence Supreme Court came up with a doctrine called as Doctrine of Basic Structure. So Supreme Court has tried to give some example in Keshwanand Bharti case that these are the example of basic structure of Constitution of India, and these basic structure elements shall not be amended, shall not be changed by Parliament even with full majority. So under Article 368 also, such basic structure cannot be touched by Parliament, and hence this debate was ultimately settled whether the Parliament's amending power are unlimited or limited. Right, so I hope through this video you have understood what is Article 13 all about. Article 13 broadly gives power to judiciary that all such laws, rules, regulation which is violative of any of the fundamental rights to the extent of violation has to be declared as null and void by judiciary. So that is what Article 13 is. All important case laws also we have discussed here. In the next video we are going to start with right to equality under Article 14. Thank you so much for watching this video.